State enforcement agencies in California executed arrests on 3 concealed carry permit holders last month for actions they believed were fully compliant with the statute. Now, they are facing felony indictments that will permanently revoke their Second Amendment rights. Listen closely. The state of California operates under the most draconian firearm regulatory framework in the nation. As of 2026, the Penal Code has shifted again. Right now, gun owners are being targeted for following legal advice that is 5 years out of date. A singular procedural error at a traffic stop, one administrative oversight at the retailer, or a geographical misunderstanding regarding carry zones, and you are facing criminal prosecution. This systemic targeting is happening to law-abiding citizens. My objective is to ensure you are not the next defendant. Number 1. The jurisdictional trap of the California CCW permit. Here is the liability scenario. You navigated the bureaucratic labyrinth in your county. You completed the mandated training, cleared the DOJ background check, and secured your permit. You operate under the assumption that this state-issued document grants you immunity statewide, so you transit to San Francisco. You are carrying concealed, and you stop for a beverage. The second you exit your vehicle, you are in violation of the Penal Code. Why? Because while California CCW permits are issued by the county, the state has engineered a minefield of prohibited locations where even valid permit holders face criminal liability. Most owners are oblivious to these statutory exclusions. Under California Penal Code 25850, possession of a loaded firearm in a prohibited zone is a misdemeanor carrying a 1-year custodial sentence and financial penalties. But here is the federal trap. If you unknowingly enter a gun-free school zone, you are triggering a federal felony statute punishable by 5 years in federal prison. Just last year, a permit holder in Los Angeles was apprehended outside a community college perimeter. He held a valid CCW. He is now battling felony charges in court. Here is your defense strategy. First, acknowledge that your CCW is null and void in any K-12 facility, university campus, government infrastructure, courthouse, airport, transit hub, or any private property with posted prohibition signage. Second, before you transport your concealed firearm anywhere in the state, you must audit local county ordinances. Municipalities have enacted restrictions that supersede state baselines. Third, access the California DOJ's prohibited locations roster immediately. Secure a physical copy, maintain it in your vehicle, and consult it prior to any transit. Fourth, if ambiguity exists, secure the firearm in a locked container within the vehicle. A felony indictment is not worth the risk. However, concealed carry is only the first vector of attack. The next legal pitfall involves open carry, and this creates immediate criminal exposure. Number 2. The rural open carry fallacy. You are in unincorporated California, perhaps utilizing public lands. You observe others open carrying, and you assume lawful precedent. Here is the grim reality. California maintains the most restrictive open carry prohibitions in the Republic, designed as a litigation trap. Open carry of loaded firearms is statutorily prohibited across nearly the entire state, including unincorporated zones. Open carry of unloaded firearms is equally criminalized in the vast majority of jurisdictions. The statutory exceptions are so narrow that they are functionally non-existent for the average citizen. Yet, eyewitness arrests for this violation on a monthly basis. Under California Penal Code 26352, openly carrying an unloaded handgun in the public domain is a misdemeanor carrying custodial time and fines. Under Penal Code 25850, the same penalties apply to loaded firearms. However, if you are within an incorporated municipality or a restricted zone, prosecutors will stack the charges. A gun owner in Sacramento faced 3 distinct counts for a single open carry event, resulting in massive fines and probation. Here is the strict legal standard. Open carry is authorized only under extreme specificities. First, you may open carry an unloaded handgun strictly while hunting with a valid licensure in authorized zones. Second, you may open carry while actively engaged in lawful target practice at a sanctioned range. Third, you may open carry on private freehold property with express owner consent. That is the extent of your liberty. If you contemplate open carry under any other conditions, cease immediately. Even in rural jurisdictions, even on Bureau of Land Management territory, the statute is absolute, and law enforcement is mandated to enforce it. Your only litigation-proof option is concealed carry with a valid permit or transporting the firearm unloaded in a locked securement. Now, even if you never carry in the public sphere, This next administrative trap occurs at the point of sale, and it is bankrupting people. Number 3. Failure to navigate the 2026 acquisition and registration protocols. The California acquisition process is a bureaucratic nightmare, and the 2026 amendments have weaponized the paperwork. You enter a retailer, select a handgun, and assume a federal form, and a 10-day cooling-off period is the extent of the requirement. Incorrect. California mandates a firearm safety certificate, a comprehensive background check via the California DOJ, a mandatory 10-day waiting period, rigid residency verification, and as of 2026, supplemental documentation for initial purchasers. Omit one requirement, submit one erroneous document, or misinterpret a single query on the affidavit, and you face denial, a flag in the DOJ database, or a charge of attempting an illegal purchase. Under California Penal Code 27540, submitting falsified data on purchase documents is a felony carrying a 3-year state prison sentence. Under Penal Code 27500, purchasing without compliant documentation is a misdemeanor. The critical danger is the cumulative effect. If you are denied and attempt a secondary purchase without resolving the administrative hold, the state views this as a pattern of illegal activity, and prosecutors will pursue maximum sentencing. Here is the operational protocol. First, secure your firearm safety certificate prior to entering the retailer. It requires a written examination and a fee, valid for 5 years. Second, produce 2 forms of government identification, your driver's license, and a utility bill or vehicle registration verifying current domicile. Third, for first-time buyers in 2026, present proof of a state-approved safety course. Fourth, when completing the Dealer Record of Sale, DROS, analyze every query. Answer with absolute precision. If a question is ambiguous, demand clarification from the dealer. Fifth, accept that the 10-day waiting period is statutory and non-negotiable. Sixth, upon retrieval, present the identical ID used at initiation. Seventh, understand that the state automatically registers every purchase. There is no separate registration action required, but the acquisition is merely the beginning. Your method of transport is the next vector for arrest. Number 4. Improper vehicular transport. You have acquired the handgun. You are in transit to your residence. The weapon is unloaded in the trunk. You believe you are compliant. You are stopped for a minor traffic infraction. The officer inquires regarding weapons. You declare the unloaded firearm in the trunk. The officer inspects it. Adjacent to your handgun is a box of ammunition. You have just violated the transport code. Why? Under California statute, firearms must be transported unloaded and in a locked container, and the ammunition must be segregated. Most owners achieve compliance on 2 out of 3, which is insufficient to prevent arrest. Under California Penal Code 25610, transporting a loaded firearm is a misdemeanor. However, the legal definition of loaded is the trap. California defines loaded as having ammunition attached to or in the immediate vicinity of the firearm, even if the chamber is empty. Courts have sustained convictions where the gun and ammo shared the same bag or trunk compartment without a rigid divider. An owner in Orange County was taken into custody because his unloaded pistol and a box of 9mm rounds occupied the same trunk space without a locked container. He incurred significant legal defense costs. Here is the strict transport protocol. First, the firearm must be mechanically unloaded. No round in the chamber, no magazine inserted. Second, the firearm must be secured in a locked container. This is defined as a secure container that is fully enclosed and locked by a padlock, key lock, combination lock, or similar device. The glove compartment is legally insufficient. The center console is insufficient unless it has a dedicated lock. Third, sequester ammunition in a completely separate locked container. If you possess only one lockbox, secure the firearm inside it and place the ammunition loose in a separate sector of the vehicle. Fourth, if you hold a CCW, you may transport a loaded firearm on your person or secured in the vehicle. Fifth, during a law enforcement interaction, immediately declare the presence, location, and condition of the firearm. Do not attempt to access it. Allow the officer to secure the scene. Now, even if you execute every protocol I have outlined, the 2026 legislative overhaul has engineered new suppression mechanisms. Number 5. Negligence regarding the 2026 statutory updates. The California legislature manufactures new liabilities annually. Most owners focus on the headline bans, assault weapons, magazine limits. But the statutes that generate arrests are the obscure clauses buried in 500-page omnibus bills. In 2026, the state enacted operational changes that directly target possession and carry. These are not public knowledge. They are legal landmines. California now mandates micro-stamping technology for all new semi-automatic handgun retail transactions. If the firearm lacks this technology, the sale is void. Violation is a criminal offense. The state has also expanded the definition of prohibited persons. Individuals with specific misdemeanor convictions within the last decade, who were previously legal, are now retroactive felons in possession. Furthermore, sensitive place restrictions have been aggressively expanded. Public parks, demonstration zones, and religious institutions are now prohibited zones, rendering your CCW invalid in these locations. Finally, penalties for storage violations have escalated. Actionable intel. First, audit your pre-2026 inventory against current possession definitions. Second, download the California DOJ's updated sensitive places matrix immediately. Third, mandatory lock protocols are now in effect for any dwelling with minors. Fourth, conduct a personal criminal history audit. A decade-old misdemeanor could now be a disqualifier. Fifth, maintain constant surveillance on legislative updates. Ignorance of the new code is a guaranteed conviction. But here is where the system destroys families. Most assume they are compliant at home, but this next oversight is catastrophic. Number 6. Criminal storage liability. You identify as a responsible owner. Your weapons are vaulted. However, your minor child hosts a peer. Your child, trained in access, displays an unloaded firearm. The peer captures an image, uploads it to social media. A third party alerts law enforcement. You are now facing criminal prosecution for enabling minor access. This scenario was prosecuted in San Diego in 2025. The owner believed he was teaching responsibility. The state charged him with criminal storage. Under California Penal Code 25100, first-degree criminal storage, resulting in injury, carries 3 years in state prison. Second degree, access without injury, is a misdemeanor. The devastating consequence is not just the prison time. It is the Child Protective Services investigation. Your custody rights are terminated. One storage error dismantles your lineage. Defense protocols. First, all firearms must be secured in a locked container or disabled with a DOJ-approved safety device when not in your direct control. Second, if a minor resides in or visits the premises, this is absolute. Third, a locked container must be resistant to forced entry. Fourth, never disclose combination codes to minors, regardless of trust levels. The state holds you strictly liable. Fifth, if the weapon is within your immediate reach, storage codes are suspended. Sixth, instruction does not equal access authorization. Even if you secure the home, this next mistake occurs when you attempt to assist a peer. Number 7. Illegal transfer of a firearm. A family member faces a security threat and requests a temporary loan of a handgun. You hand over the weapon, assuming a familial exemption. Weeks later, law enforcement intercepts the weapon in their possession. You are both indicted. California mandates that virtually all firearm transfers, including temporary loans between relatives, must process through a licensed dealer, FFL, with a background check. This is the most frequently violated statute in the state. Under Penal Code 27545, bypassing the dealer is a misdemeanor. However, if the recipient is a prohibited person, a fact you may not know, you are facing felony charges under Penal Code 27500, carrying 3 years in prison. A Fresno owner served 18 months for loaning a pistol to a cousin with an expunged DUI. Legal transfer protocol. First, route all transfers through an FFL. Second, recognize the narrow exceptions. Parent to child or grandparent to grandchild are exempt from the dealer requirement but still require DOJ paperwork, intrafamilial transfer form, submitted within 30 days. Loans are only valid if the owner remains present, or in cases of imminent documented danger for less than 30 days. Third, never assume eligibility. Let the DOJ background check assume the liability. Fourth, if a friend asks to borrow a gun, the answer is, meet me at the gun store. Paperwork is cheaper than a felony defense. Transfers are a risk, but this next item involves the hardware itself. Number 8. Possession of high-capacity feeding devices. You relocated from a free state. You retained your standard capacity magazines. You assume accessories are not firearms. Incorrect. California strictly prohibits magazines exceeding 10 rounds. A range officer observes a 15-round magazine and is mandated to report. A search warrant is executed. Police seize additional magazines. You are now facing sequential criminal counts. A Sacramento resident is fighting 6 separate charges for magazines legally acquired in Nevada. Under Penal Code 32310, importing, manufacturing, or possessing high-capacity magazines is a criminal offense. The multiplier effect is the danger. Each magazine constitutes a separate charge. 10 magazines equal 10 counts, potentially 10 years in custody. Defense strategy. First, define high capacity as any device accepting more than 10 rounds. Second, if migrating to California, purge these items prior to crossing the border. Third, Freedom Week magazines from 2019 are possession legal but cannot be transferred or imported. Fourth, permanently modify high-capacity bodies to 10 rounds using irreversible methods like riveting or epoxy. Fifth, never purchase from out-of-state online retailers who ship non-compliant items. That is a felony importation charge. Magazines are a distinct liability, but this next category targets the hardware itself, and it is generating felony arrests on a daily cycle. Number 9. Unintentional manufacturing of an unregistered assault weapon. You acquired an AR-15 pattern rifle years ago during a permissive window. You registered it. Subsequently, you elected to upgrade the platform. You installed a modern pistol grip, a collapsible stock, perhaps a flash suppressor. You retained the original lower receiver, assuming the registration remained valid. Incorrect. Under California statute, the addition of specific features transforms a compliant rifle into an illegal configuration or manufactures an entirely new unregistered assault weapon. You are now in possession of contraband. This is occurring right now to owners who believe they are grandfathered in. A singular modification triggers a felony status. Under California Penal Code 3605, possession of an unregistered assault weapon is a wobbler offense, chargeable as a felony carrying 3 years in state prison and massive fines. Manufacturing, which includes simple assembly of parts, is a strict liability felony. The catastrophic outcome is not just the prison term. A conviction strips your Second Amendment rights for life and exposes you to federal prosecution under the National Firearms Act. A Riverside owner modified a registered AR-15 with a standard magazine release. He was intercepted at a traffic stop. The state confiscated his entire collection, and he served 18 months in custody. Here is the operational doctrine for compliance. First, California defines assault weapons by a features test. For rifles, this includes a detachable magazine combined with any of the following: pistol grip, thumb hole stock, folding, telescoping stock, grenade flare launcher, flash suppressor, or forward pistol grip. Second, if you own an AR or AK platform, it must exist in one of 3 states: a registered assault weapon, if processed before the deadline, a featureless rifle, no prohibited distinctives, or a fixed magazine configuration requiring disassembly to reload. Third, never modify a registered assault weapon without a legal audit. Swapping components can legally create a new weapon that falls outside your registration. Fourth, if you are building from a stripped receiver, ensure total compliance with assault weapon statutes prior to final assembly. Fifth, utilize the California DOJ's identification flowchart. It is the only metric that matters in court. Sixth, when ambiguity exists, retain a firearms attorney before turning a wrench. We are approaching the end, but this final trap is the most common geographic error. Number 10. The border importation trap. You transit to Nevada for a competition. You transport 3 handguns, an AR-15, and bulk ammunition. You compete legally. You return. At the California state line, you encounter the agricultural inspection station. The agent inquires regarding firearms. You confirm. They request a visual inspection. They identify your AR-15 equipped with a standard magazine release. Legal in Nevada, a felony in California unless registered or featureless. You are detained. The assets are seized. You are indicted. Why? Because the moment you cross the jurisdictional line, your inventory must comply with California Penal Code. The state does not recognize the laws of Nevada, Arizona, or Oregon. Under California Penal Code 3600, importing an assault weapon is a felony punishable by up to 3 years in state prison. Under Penal Code 32310, importing high-capacity magazines is a criminal offense. The tactical reality is that border agents are trained to identify non-compliant firearms under the guise of agricultural inspection. They will execute a vehicle search. They will confiscate. An owner returning from Arizona with 4 15-round magazines was interdicted at the border, incarcerated for 2 days, and forced to pay $6,000 in defense fees to avoid a felony record. Here is the protocol for secure travel. First, Prior to exiting California, verify that every asset you intend to return with is strictly California compliant. If you transport an AR-15, it must be featureless or maglocked. No exceptions. Second, do not acquire firearms, magazines, or receivers in other states for transport back to California. All acquisitions must be shipped to a California FFL for DROS processing. Third, if you are permanently relocating to the state, audit your inventory. Sell or abandon anything that violates the code before you enter. Fourth, when transiting through California to a third-party state, you are protected by the Federal Firearm Owners Protection Act, FOPA, but strictly if the firearms are unloaded, locked, and inaccessible, and your transit is continuous without non-essential stops. Fifth, maintain physical documentation of your California registrations in the vehicle. Sixth, if compliance is in doubt, leave the hardware at home. A felony indictment is not a souvenir you want to bring back. Let us review the 10 vectors of legal exposure. First, the delusion that a CCW grants universal access. Prohibited zones will trigger an arrest. Second, the rural open carry fallacy. It is illegal in almost every jurisdiction. Third, failure to navigate the 2026 acquisition protocols. One error flags you in the system. Fourth, transporting firearms with ammunition in the same compartment. This is a loaded weapon under state law. Fifth, negligence regarding the 2026 statutory updates. New sensitive places and penalties are active. Sixth, criminal storage liability. This destroys families and invites state custody of your children. Seventh, illegal transfers to family without an FFL. Even immediate family requires a background check. Eighth, possession of high-capacity magazines. Sequential counting leads to massive sentences. Ninth, unintentional manufacturing of an assault weapon. This is a life-altering felony. 10th, the border importation trap. Inspection points are enforcement zones. Any single violation of these protocols can cost you $10,000 in retainer fees, years of liberty, and your fundamental right to bear arms. The state of California operates on strict liability. Ignorance is not a defense strategy. You are expected to know the code. Do not let statutory confusion neutralize your rights.